Professional Ethics by Dr. Hayden Smith. So we're talking about professional ethics with specific reference to the criminal justice system. In terms of professional ethics, we're talking about standards of behavior used by professionals at the personal level that's often replicated at a corporate, organizational, or agency type level. Professional ethics, when they were originally developed, were based on three basic professions: divinity and the church, the law and the legal system, and medicine. Most people will be familiar with the Hippocratic Oath. There was also some ethical boundaries and guidance provided for aspects of the military, often based on virtue ethics, ideas such as promoting the virtues of courage and bravery in the military field. Now, in criminal justice, while we have professional workers, we often use the term practitioners, so I'll use these terms to mean essentially the same things. The practitioners are people who have a specialized skill and specialized knowledge or training, and they have been trained in a certain area to deal with the criminal justice system. If we think about people who are engaged in the criminal justice system in a professional role, we know that there are certain powers that they have. This is developed through the social contract in which citizens give up certain powers to live in a safe society, and practitioners reinforce the social contract by taking certain rights from people in order to keep a safe society. So if we think about criminal justice workers, at any point in time, if you do something wrong, they have the right to arrest you, and if you go through the system, you can be incarcerated. And in some states where we still have the death penalty, a life can be taken on behalf of the system itself. So there are different professions, but we know that criminal justice as a field deals with fairly vulnerable people, whether it's victims or even offenders who often have mental health issues, physical health issues, abusive paths themselves, that we deal with a vulnerability here, so ethics takes a particular salience or importance. So professional ethics, we think about three different perspectives coming together in the criminal justice system. The first one is the practitioner themselves. This is the individual practitioner with the skills, training, and often certifications or qualifications to engage in a certain aspect of the criminal justice system. Usually in professional ethics, such as in psychology, we use the term the client. But in criminal justice, we're all often thinking of citizens, or depending on police or court or corrections, we're thinking about offenders or inmates. And we also think about the perspective of the profession itself, the overarching agency, organization, or governing body, or even the field under which the practitioner operates. If the practitioner is not engaging in ethical behavior, then the field as a whole, the profession as a whole, can suffer. Now, in order for the criminal justice system to actually function, there needs to be an element of public trust. There's a number of studies that continue in terms of trust for police, particularly, but also for the justice system, the court system, and the correctional system. And without public trust, the system itself would actually collapse. So in a lot of professional ethics in criminal justice, there's an emphasis on the practitioner to engage in the citizenship with a sense of moral decisions and to reinforce public trust. Now, in professional ethics, practitioners are often not given a do this or don't do this guidelines. Rather, they're provided ethical guidelines, which are principles, rules, or boundaries under which they should operate. Some of the more severe ones may actually be illegal and could have very severe consequences. However, other guidelines could be more generic or less severe, so they could actually be unethical while also still remaining on the side of legalities. As a general rule, however, whatever ethical guidelines are put in place for the practitioner, if the practitioner chooses to violate ethical guidelines set by the governing body or set by the organization they work for, that organization, that agency, or the profession is at risk for lawsuits. So, in other words, and it makes sense, the more unethical decisions that one makes, the more risk one faces of lawsuits in the criminal justice system. Certain governing bodies with practitioners regulate themselves. These are called internal regulations. This would be things like censoring a person, taking away their, say, their law license and disbarring them. And things can be handled within that professional body. Sometimes it could be a slap on the wrist. But other times, the ethical guidelines may reach the level of a statutory regulation in which practitioners are mandatorily authorized to report unethical behaviors of other practitioners. Nursing is an example in which there are certain ethical guidelines in which a nurse or a medical provider sees unethical practices in another provider, they are obligated to report those behaviors. If they do not, and that other person is caught for their unethical behaviors, the nurse or other practitioner could actually be found in violation of ethics just by non-reporting. Now, in terms of practitioner ethics or professional ethics, we have commonly what we call the code of ethics. These are very frequent in the criminal justice system. There is certain research that suggests that codes of ethics do in fact help reinforce moral decision making. Some of this research actually occurs in the college setting, the university setting, when a student takes a paper or completes a paper, particularly a take-home paper where they have access to the question for a week or so, and they can look up responses on the internet and write a paper at home and then bring it back the following week. Examples include like a comprehensive exam. A number of schools and a number of departments have codes of ethics that a student will sign, and they'll say things like, I did not have somebody help me with this paper, and so on. Research does suggest that these codes of ethics tend to work, particularly if the person is asked to sign one. In one funny case, in an MIT example, they found that a student signing a code of ethics helped considerably in terms of reducing issues like plagiarism and cheating, although MIT at the time did not actually have a student code of ethics. So students just signing something and reacting to a statement would often be enough to help reinforce those several guidelines. Of the principles that practitioners are expected to follow, regardless of their specific code of ethics, is actually taken from research ethics. Research ethics included a period of time in which there was no overriding consideration for doing research on people, and there was a number of clear ethical violations. So as a result, and we end up with a situation in which respect for people and risks for people were commonly violated. In a number of cases, this resulted in classic cases of ethical violations. We have the Milgram report, a Milgram study, and a number of other studies in public health as well that show that individuals partaking in research were kind of stripped of their rights. So a lot of the general principles that we find in codes of ethics come from the outcomes of these unethical studies. They tend to focus on issues of respect for people, issues of privacy and consent, the balancing of risk for the individuals with benefit to society, kind of a utilitarian view there of individuals. the selection of people, the review of research proposal, and issues of the communities of the practitioners and the funding. Now, this is much more of a research approach, but some of these general principles can also be seen in codes of ethics. Now, when we think of codes of ethics and we get a little more specific in criminal justice, some of the key virtues that practitioners are expected to follow include things like honesty. Honesty is a key aspect of all working groups in criminal justice. Obviously, kind of emerges in the news in terms of policing. Honesty is an issue about virtuous behavior, integrity, truthfulness, and being straightforward, and also the absence of lying, cheating, and stealing. Police officers come across opportunities where there may be money, drug money, access to resources that would be quite easy to take, and honesty is a good barrier to that, as well as for other workers. Integrity is linked to being honest. It also has a more general approach to moral uprightness, following moral standards, being showing integrity, and doing the right thing. Transparency is another aspect of the code of ethics. In fact, we have the Freedom of Information Act, where journalists and other people can request documents. They can make a request, and agencies have to provide documents. It could be a budget, it could be a discipline report on a person, and transparency of decisions. This shows that there is an openness in communication and an accountability. Of course, accountability in itself is often emerges. This also emerges when mistakes are made and issues of liability. Confidentiality is also a big issue. We see this with lawyers. The client-lawyer privilege and not sharing of information, but confidentiality is actually a big part that extends beyond attorney-client privilege to focus on other areas of the criminal justice system. Objectivity, this focuses on issues of fairness and following facts rather than emotions in terms of investigations, in terms of sentencing decisions in court. Respect. Respect is a very big issue in corrections. You'll often hear correctional officers talking about respect, and inmates, and particularly male inmates, tend to have a very high emphasis on the role of respect. And there's a number of studies on how correctional officers interact with inmates, and respect is a key aspect of getting people to view you as ethical and actually to follow what you ask them to do. Obedience to the law, that's pretty straightforward, and loyalty, which of course is loyalty to the organization, but it also has limitations in terms of following loyalty to an ethical group rather than loyalty to an unethical kind of approach. So we start by looking at kind of a system where we'll start by examining police or law enforcement, and then discussing courts, and then finishing with a brief discussion on corrections. And this process has a logic to it in terms of if a person commits a criminal act, in a number of cases, the first criminal justice practitioner that they'll encounter is actually a police officer or a law enforcement officer. If it progresses to the level of court hearing, then they'll engage with lawyers and judges and the courtroom proceedings. And if they are found guilty and sentenced, then they'll be sentenced to some sort of correctional system, prisons, jails, probation, or parole. So that is kind of follows the same pattern as a number of people may actually experience the criminal justice system. So law enforcement was originally started um, when Sir Robert Peel developed the idea of a code of ethics or a way of behaving in which citizen cooperation provided a very basic transaction in a democratic society. The early and current administrators of police and law enforcement, and I'll use those terms intermittently, even though there are some differences, but the administrators of police, even now, still understand that police can't be everywhere, and that trust in police is a very important concept in a democratic society. Police need people to report crimes, and they need people to be looking out for acts of deviance and criminality. And without citizen and community cooperation, police simply can't do their job. A code of ethics requires that police are not only prepared to enforce the law, but they themselves can follow the law. So that is an important distinction that a code of ethics reinforces. And the LEO Code of Ethics, Law Enforcement Officer Code of Ethics, seeks to reinforce this same idea of citizen cooperation or trust, first credited to Robert Peel, with the general public. So even though these codes of ethics have individual aspects to them, they still work towards an overall sense of trust with the community and the general public. Now, when we think of law enforcement, we do think of their varied and extensive powers. We deal with things with, you'll hear in the news about police conducting stops and searches. How are they stopping people? Is there a racial bias? Is there a socioeconomic bias? How do searches occur? What about using warrants or warrantless approaches for searches? How is force applied? There's force continuums. Are they applied correctly, or is excessive force used? What about the role of interrogation techniques? There's certain ethical approaches to those. Are they being followed or not? But these are some serious considerations and issues because they actually involve not only the interrogation or stopping of people, but the potential incarceration. So the removal, this is the first part of the system in which a citizen's rights can be removed. So ethics is very important. And one thing to note is that law enforcement in of itself is actually a very diverse group. A lot of people think of their local police officer. But in the American context, for example, we have everything from very large federal organizations to state and local groups to sheriffs to police. In some of the other areas, we might, on, for example, the Florida Panhandle, you may have a police department of 4 or 6 people. In some more rural areas, the same may apply. You also have law enforcement that engage in corrections, and then also other ones that engage in things like the forestry commissions. So law enforcement actually do a diverse set of jobs. However, there is some commonality in terms of what the code of ethics expects of them. Now you can see that in terms of overall, you can see here in terms of overall confidence in the police, it hovers around the 50 to 60% mark. This is a Gallup poll. When they're asked what percentage of adults have a great deal or quite a lot of confidence in the police. You can see around 2015 it took a dip. This was because some confidence was lost when there was some use of force issues applied to people of color. So there is a connection between the perceptions of citizens and what's often seen on the media in terms of the way police carry out their behaviors and do their jobs. This does vary over time, and of course we want a higher number in terms of perceptions of confidence of the way police operate. Sometimes this can take on trends in which it's not all of society who increase or lose confidence in police, but parts of society. So after these events, in terms of when use of force was perhaps seen as being a bit excessive, we actually saw a reduction of confidence by Hispanics, by blacks, by liberals, by young people, and by those who identify as Democrats in politics. We saw an increase slightly in whites, in conservatives, in older groups, 55 and older, and in those who identify as Republican. Slight increases in some cases. So these images of how practitioners engage in behaviors and whether they are ethical does in fact influence the trust or confidence that people have in the police. One of the main aspects of police ethics, and long studied and an important one, is that police themselves can often maintain a subculture. What happens in this case is that police are often handed a lot of social problems that in some cases they're not equipped to deal with. They're equipped to deal with certain types of crime. However, they may come across a complicated situation of domestic violence. A woman, for example, may call them for domestic violence on a husband, and they get to the scene, they try to arrest the husband, she may change her mind, 2 hours later they're called back to the house, and so on. They may also be called for issues of homelessness, drug addiction, mental illness, and a bunch of other things that are not actually firmly locked in the criminal justice world. Sometimes they deal with things to do with addiction, low socioeconomic status, and some other issues. Police are often understood and misunderstood, and a number of traditional studies have found that police will revert to a subculture in which they don't associate with a lot of people outside of the police culture. For example, they'll play on police baseball leagues, they'll go to police bars to socialize, and then they'll work with other police officers, and the spouses of police officers will also engage in those social circles. What this can often occur in terms of ethics is what they call the blue wall of silence, also called the blue code or the blue shield. This suggests that there's an unwritten code of laws in which you're in the blue wall or the police family. And that once you're in that family, it becomes very difficult to report the unethical behaviors of other officers. And that you yourself may be caught in unethical behaviors. An example of this is perjury, or what's called testifying, in which you do testimony, but you give false, misleading, or incomplete testimony. You violate ethics not only in the police world, but in the court world. Now, there seems to be large commissions that happen about every 10 years that investigate this. Sometimes there'll be a particular officer that is seen as unethical. Sometimes it's seen as more generic through a department or a district. In 1992, one of the big commissions found that that officers were engaging in unethical behavior. However, they were not necessarily doing it for reasons of greed or to take money, but they were just distributing justice in their own way. They often felt that the person that they were lying about or being unethical towards actually deserved it, and that they should be incarcerated or they should be found guilty, and they may be getting away with it. So they're actually moving from police to being judges. And this commission was in response to the Rodney King beating of 1991. This is not to say, and this is important, that police officers are unethical. In fact, a number of studies show that police are very ethical and are open to a great deal of temptation, but they generally do the right thing. What it does show is that when engaged in a subculture, it's very easy for subcultures to block out um, officers reporting on other officers, or what they call whistleblowers. A person who stops and says, wait, there's unethical behaviors and there's no way to stop this. So, for example, during the Mullen Commission of 92, one of the police officers made the following statement. If a cop decided to tell on me, his career is ruined. He's going to be labeled as a rat. So, in other words, there was a culture in which, if one unethical police officer did lie, cheat, steal, perjury, engage in excessive uses of force, and so on, there was a culture or a blue wall of silence in which, if a person stepped forward to highlight that unethical behavior, their own working life would be very difficult. They wouldn't be promoted, and they'd be ostracized by other officers. Another area in which police officers are often have to negotiate ethical decisions has to do with informants. Uh, Police officers work for a certain amount of time of a day and then they go home. Informants are not off the clock. They are often people who themselves are engaged in criminal behaviors, so they tend to have a lot of information for the police officer. They have more information than the general public, and they have more information than other police officers. They're the type of informants that can go into drug houses to see what's happening because they themselves are buying drugs. They may also be part of terrorist organizations and access different groups and delinquent groups that police simply just cannot access. They are a very important part of the criminal justice system. However, a police officer often has to straddle their roles because informants will come to see police officers as their friends. Police, on the other hand, are actually their handlers, so they have to manage the informant while also maintaining an ethical distance. And there are ethical guidelines for police, as well as trainings on how to do this. When not followed, the unethical treatment of an informant can lead to all sorts of terrible results. Not only will crimes no longer be solved, but the informant themselves can be hurt or killed, as well as the police and the responding police. If they're given incorrect information, police may arrive on a scene to find the bad guys already armed and ready for a shootout or ready to hurt them. So it's a very dangerous role to take for informants, particularly street-level informants. There's often something they wish to gain out of it. Sometimes it's just simply a perception of friendship with the police. Sometimes they think that they may get what's called a get-out-of-jail-free card, which once again raises ethical issues for policing. But this is another type of issue that law enforcement and police face. So how do law enforcement deal with this? Well, here's an example of perhaps the most widely used law enforcement code of ethics. This is a very general approach, and law enforcement officers would read this. Sometimes they will read this out loud at a graduation as they become police officers. And sometimes they'll sign this code of ethics. It's general, and it says that a law enforcement officer is to serve people, to safeguard lives and property, protect the innocent, and deals with issues of constitutional rights of people. It says men throughout, should probably say humans, but it says that also the second paragraph says that law enforcement officers will keep their private life in order and not open themselves up to criminal or what they call sullied acts there. And they will remain in a confidential role. Third paragraph says that they will be fair. They will not engage in personal feelings, prejudices, friendships to influence decisions. Uh, you can think of a number of examples that would come up. Example, finding a friend driving home drunk, and letting that friendship let you give them a free pass. There's a number of real world challenges here, and also the issue there of unnecessary force or violence, or even accepting gratuities. The acceptance of gratuities is actually a kind of a big ongoing ethical issue for police. In the old days, police would often camp out at night at a particular coffee shop or restaurant. The owner of that coffee shop, if it was an all-night diner, for example, would give them free food, free coffee, with the peace of mind that there was 4, 5, 6 police cars outside their diner, so the chances of them getting robbed were probably next to nothing. However, it does raise certain issues that people who were at other diners who didn't give free meals then argued, well, you're kind of protecting one place and not my place. So it also raises the issue, even for one cup of coffee a day, of, well, what does the police officer owe the person giving them that cup of coffee? And at the end, it has a brief sentence about the issue of public faith, trust, ethics, and so on. So this is a very general code of ethics. This is perhaps the most well-known and well-used one for law enforcement. Another example, and this one's taken from the state of Victoria in Australia, is a code of conduct and a code of ethics that is much more detailed. So it starts with the mission statement of police: preserve the peace, protect life and property, prevent offences, detect and apprehend offenders, help those in need. Then there's a code of ethics, and it's I uphold the right in my role within Victoria Police by acting impartially, with integrity, and by providing service excellence to everyone. So a role on service. So this looks fairly short until we have a look at the next page that goes into great detail about all of the values. We see here what we call virtue ethics: integrity, leadership, flexibility, respect, support, and professionalism. This will be one part of the package that these police officers receive and follow. And then you can see the code of conduct is actually listed, and this is just simply a table of contents, and there's a whole bunch of particular subtopics here. Everything from responsibilities to confidentiality, alcohol and drugs, fitness for work, conduct outside work hours. You can imagine there's a number of ethical guidelines for these type of things. 13 pages. Similar codes of ethics. As I said, law enforcement's a diverse group. So we have things like police who work in the military. So this is a code of ethics by the military police. It says, I am a soldier of the United States Army. I am of the troops and for the troops. Allegiance to country, duties, integrity, loyalty, and honesty. So some virtues there. Assist and protect fellow soldiers in a manner that is fair, courteous, and impartial. I will promote by personal example the highest standards of soldiering, stressing performance and professionalism. I will strive to merit the respect of others. So respect, we have another virtue there. Seeking no favor because of position. So we're talking about impartiality there, but instead the satisfaction of a mission accomplished and a job well done. So we see some very interesting thoughts in this short statement. We see a number of virtues, virtue ethics showing up there, and impartiality and respect for higher ethical standards. So somewhat different from the standard police code of ethics, but still in that same field. Professional ethics, as I said, has real-world application. And this is the news clipping from St. Petersburg, Florida, in which officers were disciplined for taking gratuities. So as I mentioned, gratuities is often a um, important issue, the free cup of coffee and so on. It says one officer was fired and 2 others were disciplined after an internal investigation found they routinely accepted items from a local convenience store without paying for them. Accepting gratuities is a departmental policy violation and a violation of the officer's code of ethics. So you can see the code of ethics in some ways overlaps with the policy of the department itself. Obviously, one officer did something of more severity and was fired, and the 2 others were disciplined, maybe some time off on a suspension or some other form of discipline. But these code of ethics do have real world implications, even when you think about something such as not paying for small items from a local convenience store. Next, we start to think about courts. So we've moved from the issue of police, we're moving towards the issues surrounding practitioner ethics in courts. So courts are typically a government institution that has the authority to deal with legal disputes between parties, particularly civil, criminal, and administrative matters, and focuses on the rule of law. Practitioners in this setting, if we think about the courtroom, we're typically talking about lawyers. I'll use terms lawyers, attorneys, etc., just kind of a catch-all term, as well as judges. At the individual level, we frequently see things in the news about lawyers, judges, and issues of ethics. But also, when these things rise to the issue of policies, we think about the ethics of certain sentencing guidelines. One of the most prime examples of this, and used in a lot of criminal justice introductory textbooks, is the 100-to-1 crack versus powder cocaine sentencing disparity. Now, what this means is that crack cocaine and powder cocaine are very similar in terms of their impact, in terms of their potency. However, crack cocaine is often used by low socioeconomic and people of color. Powder cocaine associated with high socioeconomic and not people of color. The sentencing guideline had about a 100-to-1 disparity for people having crack versus the same amount of powder cocaine. In recent years, this has been remedied, but it seemed to suggest that there was an unethical distribution of sentencing based on this one substance that was presented in 2 different ways for 2 different types or demographic groups of people. Okay. For example, for 5 grams of powder cocaine, generally there was a mandatory sentence for a first-time offender of probation. For the same amount, 5 grams of crack cocaine, there would be 5 years incarceration. And we see all the way up to 5,000 grams, powder cocaine would get somebody 10 years incarceration. Crack cocaine, we're moving closer to 20 years. So these are unethical policies, which of course should not be confused with the unethical behaviors of individual practitioners, but it's still an interesting aspect of the court system. So now we think of lawyers and attorneys. Every state or territory in the United States has a code of conduct that defines these codes and rules of of ethics. Lawyers are perhaps, out of every practitioner group, the ones that are most associated between unethical activities having a very tangible negative consequence. They have a great degree of discretion in what they do and a great degree of trust. And when this trust is violated, they can get a slap on the wrist all the way up to being disbarred by their state bar association, and they can no longer practice law. So the American Bar Association developed what's called the Model Rules of Professional Conduct. This is a very influential set of rules. This is basically their code of conduct. And some of the main issues that it deals with are things like the relationship between the client and the lawyer. In a number of states, for example, a lawyer cannot have sexual relations with a current client of the lawyer. And in some small number of states, if there was already a pre-existing sexual relationship between the lawyer and the client, then that's fine. But it cannot happen after they've engaged in the contract itself to work together. Once the lawyer takes on a client, you can't have a new sexual relationship. But in most states, you can't have any sexual relationship at all. The lawyer as an advocate. So in this code of conduct, it is expected that a lawyer will act as an advocate for the client. So you will sometimes hear about proceedings in which a person, often an inmate, for example, will appeal their case because they'll say that their lawyer just simply didn't do an adequate job. They didn't act as my advocate. They didn't perform the job they were supposed to. They were incompetent, and I would like kind of a retrial with a new lawyer. Another code of conduct deals with the way that the lawyer should deal with people other than their clients. So in the courtroom setting, or even when some lawyers go into prisons or jails to talk to clients, the lawyer has to be careful about what legal advice they give to that person. They're generally suggested that the lawyer should advise that person seeks counsel, makes a contract, and then has an assigned lawyer. But the lawyer cannot just walk through jails or prison giving flippant advice to people that are not currently represented. Another code of conduct deals with confidentiality, and there are exceptions, but generally the lawyers are not should not be knowingly given confidential information or secrets of the client. So there's a lot of confidentiality issues there. Another way of thinking about this code of conduct is the model rules of professional conduct for lawyers is actually a fairly big document. So if we think about the table of contents, here's kind of the key themes that they break the subtopics down into. The client-lawyer relationship, the lawyer role as a counselor to the client, the lawyer role as an advocate, transactions and interactions with people other than the clients, the role of law firms and associations, the lawyer's engagement with public service, the information the lawyer gives about legal services, and a general category of maintaining the integrity of the profession. This code of conduct is too big to post in this presentation, but if you just consider the table of contents, you can see some general kind of categories that lawyers are placed under in terms of following ethical decision making. A similar approach is used by the International Bar Association. In this case, it follows a set of rules, such as Rule 1, you must follow all ethical standards of the jurisdiction in which you're working. Rule 2, honor integrity of the legal profession. And once again, like the police example, this follows in one's private life, not just in public life. Abstaining from any behavior that will discredit the profession. Rule 3, the role of independence, not to be swayed. Rule 4, the treatment of colleagues with courtesy and fairness. Let's go to the next one. Rule 5 deals with laws and customs in different countries, as well as issues of confidentiality. Rule 6, due respect to the court, showing respect, reinforcing the interests of the client, and never giving the court incorrect information or advice that is contrary to the law. Rule 7, improper for lawyers to communicate about a particular case directly with the person they are not representing, so this also deals with confidentiality issues. Rule 8, the way that the lawyer advertises or solicits business. Rule 9, the means by which a lawyer will consent to handle a case. 10, honest opinion. This deals with honesty and diligence, as well as assign if they are working for an indigent person, that is a person who can't afford to pay for a lawyer. So that follows the international standards, which are very close to the state, federal, etc. code of conduct for lawyers. What happens if a lawyer does not follow the codes of conduct? Well, every state has a bar association, as mentioned, and you can look in the state and go to matters that have to do, often they go to the Supreme Court for a final decision on an attorney. I took out the names of the person here because it doesn't really matter, but I looked up some different cases in South Carolina, and in this case, the punishment was a public reprimand for an attorney. And you'll see a bunch of legal gobbledygook, and this opinion was about 6-7 pages long, explained what the person did wrong with more detail. The lawyer admitted misconduct, and the punishment was a public reprimand, a suspension of 9 months. The lawyer had to pay the costs occurred in the investigation and the prosecution, and then there was some punishments in terms of the lawyer completing legal ethics and practice program ethics school and different types of educational programs. So this lawyer was not disbarred in this case, but they had to do some trainings, and this was more or less a suspension, as well as a public reprimand, because this is a public document. If you were selecting a lawyer, you could see that this person had run into some trouble before, and you could read the case and you could find out what they did. Another example I found, the respondent, and I blanked out their name, admitted misconduct. They misappropriated $171,000 from a trust. There were formal charges, and the panel who reviews these ethical issues recommended that the lawyer was disbarred, and the lawyer was. So that lawyer could not practice law in the state of South Carolina, and their name was on public record, and they were disbarred from practicing law. One more example. In this case, the attorney violated misconduct rules and was suspended for 90 days for what they did. Once again, it would be like a 6 to 10 page explanation in detail of what the person did and where the violation occurred. So we can see that they actually have real-world consequences for unethical decision-making with lawyers, and it becomes part of the public record. It is not just handled in-house by an agency and organization, but it's actually posted on the internet and it's public record. The same applies for judges. For example, federal judges have a code of conduct, and this is a set of ethical principles they're expected to follow. And we see the same type of virtues: integrity, independence, impartiality, all of the basics that you see in the criminal justice and court system. Some of the factors that are kind of like taken in with judges are judges may not hear cases in which they have a personal knowledge of the facts, a personal bias, involvement in the case as a lawyer, or in any sort of matter. It's supposed to be the virtue of impartiality is heightened, obviously, in the case of judges. The final part deals with judges' interaction in public service and education, because judges are often expected to engage in society, in universities, or in political settings, the code of conduct also deals with their writing, speaking, and teaching um, in these avenues. So just like lawyers, judges have a model code, a model code of judicial conduct, and this is a little bit different. It's set out by canons. There's actually sub areas and explanations for each canon, but broad groups. You'll see it's similar, though somewhat different from the lawyers. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid the appearance of impropriety. So it's not just doing something wrong or being partial or biased. It's also the appearance of those things. Number two, once again, impartiality, competence, and diligence. Number three, minimize any sort of risk of conflict. Four, not engage in political or campaign activity. Once again, independence, integrity, impartiality. So we keep seeing the three I's: independence, integrity, and impartiality. Similar, though very distinct from lawyers. Five, what judges do in their time outside of work to reduce conflict. And six, issues to do with compensation. Obviously, if judges receive certain forms of compensation from certain groups, lobbying groups, political groups, they could be swayed in their decisions. It could represent a biased thought process. Just like the lawyers, judges are also can also receive ethical punishments for engaged in ethical behaviors and violating the codes of conduct. However, there is also, just like with lawyers, updates as technology changes, as other issues emerge. So for the code of conduct for judges, what's called the published advisory opinions are often presented as a new issue comes up. And these often apply to broad ethical issues. Things like if a spouse works for a political organization, what is the ethical role of the judge if they work in the same state, for example? So some of these issues may come up on a case-by-case basis, but the code of conduct is regularly updated to include new issues. In terms of judges, there's one interesting study from contently.org. You can find the full study. They looked at data from 12 states, and they found that there was a number of complaints, and in most cases they were dismissed. So this was people complaining about the behavior of judges and the acts and the ethics of judges, and it was usually dismissed. And in some cases there was some disciplinary action. It kind of fluctuated over time. But in these 12 states, over a period of 5 years, from about 2010 to 2014, those 5 years, there was 19 judges that were removed due to ethical complaints and behaviors. So we're looking at 12 states, just about one and a half judges every 5 years. So every couple of years, 2.5 years, there's about one judge that is removed. So not too frequently are they actually removed compared to the number of lawyers who are disbarred, but there's a lot more lawyers than there are judges. But once again, there are consequences for unethical acts and not following the code of conduct, even in the case of judges. Our last field of discussion, so we think about the person who interacts with the police, moves to courts, and then if found guilty and incarcerated, or they move to the area of corrections. Now, for corrections, there's an important distinction. There's what we call institutional corrections that are jails and prisons. So, institutional meaning the person will reside inside that facility. And then we have community corrections, which is probation and parole. The greatest number of people who end up in corrections will end up on probation and will never see a facility such as a prison or a jail. And the smallest number that will end up will probably be prison. Prison is for serious felonies, usually the sentence is a year or two or more, and jail is for less serious, like misdemeanor, and smaller sentences of a year or two or less. Jail is often linked towards issues of probation, and prison is linked towards being on parole. So that's kind of the 101 of corrections. For ethics, I'm going to focus mostly on institutional corrections, specifically jails and prisons, for the reason that I also would like to talk about the ethics of healthcare workers that you don't find typically in probation and parole systems. Because people reside in prisons and jails as inmates, there's a need to provide mental health, physical health care, and therefore those workers enter those facilities. Probation and parole, these needs are met in the community by doctors, nurses, etc., who are already in the community. So corrections feature diverse staff that actually have their own codes of ethics. Most people just think of the security staff or correctional officers. But if you actually go to a prison or a jail, you'll see that the people coming and going, the practitioners, the workers, are pretty much non-stop, and there's all different types. Correctional officers are those individuals who, in the practitioner role, deal mostly with matters of security. Their focus and their number one concern is issues of security, although they do have a number of roles. We also want to talk about the group of healthcare staff, and this focuses on physical health and mental health. And we're not going to talk too much about this, but there are the other groups, such as practitioners and workers who work on the physical plan itself, those who bring in food and deal with the nutrition for inmates, and a big field which is prison industries, which could be anything from a welding workshop, educational training, job preparation training, a greyhound or dog program, welding shop, woodwork shop, and the people who run those industries often have their own set of ethics too, although they're usually more in a training / educational role. So correctional officers and the frontline staff do have their own code of ethics as well and expectations of professional conduct. These core values, the virtue ethics, are discipline, being judicial, truthfulness, vigilance, respect for human rights, and a sense of responsibility. The vigilance is one of those virtues we don't see too much in the other practitioner ethics, but vigilance is a clear connection to the issue of security, institutional security. Now, these standards, these codes of ethics are set down by the American Correctional Association. We have federal, state, and local prisons and jails. And so this is kind of a generic approach, even though there may be more specific codes of ethics for facilities that may be more focused on mental health, or there are some different types of prisons and jails, even things like boot camps. So the ACA, the American Correctional Association, also publishes a set of standards which applies more to the facility itself. That could be anything from the standards of food preparation, the temperature of the showers, the changing of linen, educational access to health care, These are basically standards or benchmarks for the facility. But we're still talking about a code of ethics by the American Correctional Association for individual practitioners to follow. What are the foundational ethics and code of ethics that can guide decisions? Now, one important term for people who don't study this is please try to avoid the term guard. They're called correctional officers. Uh, Guard is an outdated term. These correctional officers are often kind of quasi psychologists themselves because they deal with a lot of issues with inmates. Inmates are a vulnerable population who often have a lot of physical and mental health needs. And so correctional officers are usually drawn into a number of different working roles. And while they do have an emphasis on security, guard kind of makes their working life redundant and very reductionistic in terms of one function. Makes them sound like guard dogs when they're actually correctional officers and they do a number of different jobs every day. So if we look at the code of ethics for correctional officers, we can see here at the opening statement by the ACA, issues reinforcement of honesty, respect for dignity and individuality of human beings, and a commitment to professional and compassionate service. So if we go down, we look for key terms in this code of ethics. Respect and protect the rights of inmates. Treat every situation with concern for welfare. Maintain relationship with colleagues for mutual respect. So so far we've seen respect twice, and respect, as I mentioned earlier, is a big virtue in correctional facilities. Making criticisms of their colleagues or agency when constructive. Respect again in terms of the discipline. Honor the public rights for information. That gets back to the issue of transparency discussed earlier. Members shall respect, so we've actually seen respect about 4 times now, and protect the right of the public to be safeguarded from criminal activity. Members shall refrain from using their positions to secure personal privileges or advantages. The remaining code of ethics talk about impartiality, refraining from entering into activities that have a conflict of interest, much like the judge's code of ethics. Refrain from accepting any gifts, services, or favors that could impair their duties. So this is an important code here, and this particular focus, because inmates or families of inmates could offer certain favors, services. They could buy the correctional officer a gift of some kind and expect that the inmate received different treatment from other inmates, even as small as a change of a cell, different food, or certain privileges. And that can lead to chaos in an institutional setting. Members shall differentiate between personal statements and those made on behalf of the agency. You can see here there is a obligation to report any corrupt or unethical behavior. So this is actually breaking the wall of silence by promoting the reporting of other officers who engage in inappropriate behavior. Issues of not discriminating based on race, gender, creed, origin, religious affiliation, age, disability, or other forms of discrimination. Confidentiality and private information. Officers will actually know quite a lot about an individual inmate's mental health and physical health status. This could emerge in the issues of knowing that an inmate, for example, is HIV positive or has some mental health diagnosis. And sometimes correctional officers live in the communities that inmates return to, or inmates' families do also live. So they have to be very careful about what they talk about outside of work. Members shall follow rules And finally, we get respect again, promote to the workspace that's um, safe, healthy, and free of harassment. Here's another way of thinking about it, the code of ethics that correctional officers will often sign or look at. And here's some basic rights that the um, inmates are entitled to and that the correctional officer should ensure that they have, and the responsibilities of sentence offenders. There's a repetition of issues such as fairness, providing rights of living conditions, avoidance of discrimination, access to health care, access to education, and so on. So, some areas in which correctional officers have been challenged in terms of ethics in the past. One of the most famous examples, and one used in a lot of corrections textbooks, occurred from about the 1960s to early 1980s. And during this time in Texas, Texas correctional officers would handpick certain inmates as a way to address gangs and keep problem inmates in line. You can see in this picture, these inmates even had weapons, and these inmates became quasi-correctional officers and would do the job for them. So the officers were basically turning one group of inmates into being the leaders of the vast majority of inmates. In some cases, they would encourage these building tenders or special inmates to physically beat down disruptive inmates, and then the prison gangs would often respond with violence because they would say, well, you're not a correctional officer, you're just another inmate. In 1980, an inmate named Ruiz sued the director of the Texas system, Estelle, and the famous case Ruiz versus Estelle remains one of the most well-known and influential correctional lawsuits. Almost 40 years later, it still remains as probably having the most effect in terms of dealing with overcrowding, issues of not being able to access health care, and having security, particularly these building tenders, operate in abusive and very physical ways that violated constitutional rights. Ruiz versus Estelle was basically end of the building tenders system, one that you could see faces obvious unethical standards, particularly when a group such as correctional officers who have a code of ethics are handing the responsibility of the job to another group, inmates, who don't. They're under no obligation to follow a code of ethics. Another area that emerges for correctional officers, and one that the general public tends to be focused on, deals with issues of sexuality. If there's one thing after teaching corrections so long that I find is when you talk about prisons and jails, a lot of people, and I'm not sure why, immediately go to topics of sexuality. But I'm talking in this regard about the practitioner of the correctional officer and some things that have emerged in terms of sexual misconduct by staff. First, the majority of these interactions between staff and inmates are what you would call consensual in a traditional model. That means there's no physical force. Both of the parties seem to be interested in a relationship. They can be a female correctional officer and a male inmate, or a male correctional officer and a female inmate, or in some cases, a homosexual gay relationship. However, this often is just a basic statistical fact that you'll have a large number of inmates, and people sometimes are attracted to each other. However, correctional officers and the codes of ethics that they follow show that for inmates, there's an issue of diminished consent. An incarcerated person cannot consent in the same way that somebody in regular society can consent. And for the correctional officer, engaging in this behavior puts them at great risk for violating the codes of conduct set down by the correctional officer standards. Um, Engaged in sexual behaviors with an inmate may give that inmate or even other inmates who know about it um, the opportunity to exploit the officer and to have the officer engage in bias, favoritism, and preferential treatment. So a number of jails and prisons, in fact all of them, practice a zero tolerance policy on sexual interactions between staff and inmates. They practice a similar thing on inmate sexuality, but that's not what I'm talking about here because we're focusing on practitioners. Now, this emerges in other forms, such as sexual harassment. A sexualized workplace may include something where cartoons are posted and sexual jokes are told, and this is unacceptable in this setting and by correctional staff, by correctional officers. It also can occur in issues of privacy. So inmates do actually have some privacy rights. They must be balanced with the security of the institution. However, there's certain practices, such as an officer leering at inmates in a shower, that violate privacy rights. One of the most common practices, if you ever visit a prison or a jail, will be if a officer of an opposite gender is on the dorm, it will be announced to those on the dorm. So, for example, if it's a male institution and a female correctional officer comes to the dorm, you'll often hear an announcement, female on the dorm, which lets the male inmates who are using the shower, the toilet, or any other sort of area like that, opportunity to cover themselves, get dressed, and have a sense of privacy while also maintaining the security needs of the institution. If an officer is leering or just pops up in order to look at inmates in the shower, bathroom, etc., this is also an act of sexual misconduct. The broad group of sexual misconduct also, of course, it does include cases in which there are sexual assaults, sexual abuse, which are in which the inmate has outright expressed no interest in a quasi-consensual relationship. They've actually rejected this idea, and there's been abuse or a rape of some kind. But it also, as I mentioned, includes sexual harassment in the form of comments, sexual conduct, conduct of a sexual nature, such as masturbating, obscenity, and violations of privacy. So there's a lot of behaviors that can fall into this, and with each of them, there's certain policies and practices. Now, when an officer does engage in sexual assault, you can see here this one officer was found guilty of a sexual contact with a inmate 8 times with the female inmate. The officer received 1 year and 8 months in prison, and will have to register as a sex offender, as well, of course, losing his job. And the woman since filed a civil lawsuit against the officer, also against his co-workers and supervisors, claiming that they knew and that they did nothing to protect her, and that this was non-consensual, and that he used his position as a correctional officer to to force her into these acts. So there are, once again, severe consequences for not following codes of ethics, particularly when you deal with issues like this. A side note is in 2003, the Prison Rape Elimination Act was formed, and the goal was to stop sexual harassment and or sexual assault in all federal, state, and local institutions, so that's jails and prisons. This was a large amount of money that was dedicated towards training and educating correctional officers and the inmates. Inmates had to understand what their rights were. Correctional officers need to understand the do's and the don'ts, which in a number of ways did follow a code of ethics. There was a reinforcement of protocols and for inmates. So if they did feel they were victimized, or if they were victimized, they would understand what their access was to mental health, physical health, a rape kit, for example, and if they wanted to press charges on an inmate, or in this case, a correctional officer. This was an evidence-based approach that had large grants and has shown to be effective. So with a lot of issues with criminal justice like this that was ignored for a long time, it could be addressed correctly. However, the role of the code of ethics reinforces these approaches to stopping unethical behavior by practitioners. A final group worth mentioning are correctional healthcare workers. And this is a very broad group that deals with physical and mental health issues. Inmates are often vulnerable to physical and mental health issues. A number of them have had traumatic lifestyles, bad childhoods, lives of addictions and violence, maybe some living on the street, low socioeconomic. They may have a large number of chronic conditions. And so the practitioners who you'll see enter jails and prisons are varied, but they tend to include doctors, and in some cases, depending on the facility, you may have an OBGYN. In female facilities, you have female inmates who will be incarcerated while pregnant, and they will actually need OBGYN checkups, and they'll end up having the baby at a hospital while they're incarcerated. They'll take them to hospital and then take the mother back after a few days. You may need a geriatric specialist as we get an aging inmate population, so some doctors with specialties for elderly inmates, nurses, dentists, psychologists or psychiatrists, social workers, counselors, and this is just the surface of some of the practitioners who will be entering jails and prisons on a daily basis. One of the interesting things that happens with codes of ethics here is their code of ethics will be different from correctional officers. Correctional officers have a primary focus towards security of the institution and the protection of inmates from other inmates and staff from inmates and the general public from certain inmates. These healthcare workers have a different focus. They're not focused on security, although the two groups do work together, but their primary skill set has to do with matters of healthcare, physical and mental health. So as a result, these groups need a distinct and different code of ethics. Here's one from the American Correctional Health Services Association. This is the introduction that talks about the principles for people, practitioners within this group, and it's a professional association. It talks about objectives and looking at the fundamental values of correctional health professionals and ethical conflicts. So the goal is to help practitioners deal with ethical conflicts in the correctional healthcare setting. These principles date back to 1990, so they've been in existence for quite some time. Let's have a look at them. Principle number one, respect the law, but recognize a responsibility in the best interest of the patient. Number two, evaluate the inmate as a patient or client. Three, render treatment only when it's justifiable to a diagnosis. This could be something where inmates ask for medications just because being in jail or prison is difficult, so they may ask for medications just to pass the time. Four, afford inmates the right to refuse care and treatment. You can't force certain care and treatment upon an individual. For example, in South Carolina, you can't force psychiatric medication on an inmate, even though it may seem like it's in their own best interest, but you can't do that. Number five, provide sound privacy during healthcare services. And in other words, don't conduct healthcare in a large open forum and discuss diagnosis and other aspects of the inmate's privacy. You could see that privacy is a big issue as we compare security issues to healthcare issues. Number six, provide healthcare to all inmates regardless of custody, meaning high maximum level inmates all the way down to minimum level. Uh, Healthcare workers need to identify themselves and not represent themselves in some other form. 8, how specimens and diagnoses are collected. Number 9 deals with cavity searches, as inmates may hide weapons and or drugs in some unusual places, and so follow proper techniques. Um, we're not in a patient-provider relationship. This can blur the boundaries of whether the healthcare worker is engaged in a healthcare activity or a security-based activity. Number 10 is a big one, not to be involved in any aspect of execution of the death penalty. Um, there's a number of documentaries on this issue. When the death penalty is administered, it's done by lethal injection. In the past, healthcare workers would insert the needle and would assist in the process. However, this is a violation of the Hippocratic Oath, which states, first do no harm. Surely, assisting in the death penalty is harming that individual. Regardless of whether the person feels like they should be executed, the worker thinks that the inmate should be executed, they are actually involved in a process that leads to the death of a human, which is a direct violation of their own code of ethics governed by the healthcare profession. Um, However, what happens is that when the death penalty is administered without healthcare workers, it was done and continues to be done in many cases by the warden of that prison. In some cases, there was botched executions because the individual being executed may have been an intravenous drug user, and the warden would be using the needles and poking around looking for a vein in order to execute the person. They were not trained in terms of healthcare, and they're not trained like a nurse to find veins and to give needles. And so you would end up with these botched executions that were very difficult to watch and may have moved into the state of being a cruel and unusual punishment for that person. Um, the profession of healthcare workers has been adamant in recent years about not having healthcare workers in any aspect of the execution process, as it's a violation of the principles of the field. So that's an interesting conflict that one finds, and a moral and an ethical dilemma that if you want to do more research on this, like I said, some interesting reading and some interesting documentaries on the topic. Number 11, ensure that all medical information is confidential. And this can be difficult in a prison or a jail where everyone is living with each other and on top of each other in terms of small spaces. You'll also sometimes have inmates who help out in the medical setting and do a kind of in prison, in jail working job. And so they will also be around information that should be confidential and held in a confidential setting. Number 12, do not participate in functions such as escorting inmates, transferring inmates, supervising inmates, and uses of force. These are security issues. These are not healthcare issues. And then the number 13 is the issue of biomedical research, which traditionally before the use of IRBs and research ethics, um, inmates represented a very easy and accessible group for unethical experiments. Um, they were pushed away from society, so people who wanted to test medications and and other type of new advanced treatments would often use inmates. In some cases, even suggesting they would be released earlier or paying them some money because they were literally a captive population. So obviously, some ethics are very important in that manner. So to summarize, practitioner ethics in the criminal justice system is a vast group. We can see some overlaps in terms of our major groups that we looked at today. We can see issues of impartiality, confidentiality, fairness, and dedication towards the missions of the individual profession under which these workers practice. However, it's not exclusive, and other groups who engage in the system also have their own practitioner ethics. I won't get into them today, but there's a number of victim service organizations that engage with the criminal justice system, all the way from police, courts, and corrections. There's drug and alcohol agencies that have their own ethics. Forensic examiners and lab technicians. You may have seen in the news that there's sometimes breaches of labs where lab results are returned or not conducted correctly, and the way that forensic examiners examine everything from a blood test to an autopsy is done incorrectly. Forensic, by the way, just means something to do with the court. A lot of people think it means something to do with cutting up a human body, but it just means something to do with the court. But these people may work in a lab, and so they need their own ethical standards to follow the proceedings in that setting. There's ethics for expert witnesses who engage in court proceedings. There's also certain ethics for administrative staff. These are administrators that work in police agencies, court settings, such as a state house of a state, and correctional agencies that, while not being practitioners like police or correctional officers, also need to have a code of ethics and a manner to which they deal with moral dilemmas too. And other groups such as advocates and politicians are often engaged in the criminal justice system, and they also need their own code of conduct, particularly politicians. So in conclusion, we can see that practitioner ethics for different professions have come a very long way from the original three areas of divinity, law, and medicine. Now they're for a very specific grouping of practitioners, often based on their roles, obligations, and expectations. We can see in certain situations where it would be very easy to blur the lines. For example, correctional officers and healthcare workers in a prison often have to negotiate whether a moral dilemma is one of security or is one of healthcare. And those two professional forces will butt heads sometimes. And it's up to each practitioner group to follow their own moral decisions based on their own training and revisiting the code of ethics that their profession lays down. They have a code of ethics for themselves, and they have a code of ethics that reflects the goals of the profession. These are not abstract codes. As you can see, there's consequences when people don't follow the codes. However, not only are they things that have severe consequences when not followed, but moral decisions for practitioners are things that they will deal with almost every single day. They may be small things, such as a police officer accepting a cup of coffee, a inmate asking an officer if they could change cells. They may be a big thing, such as the use of force or sexual assaults. But regardless, practitioners will be facing these moral decisions in the workplace. They'll also be facing what to do with other practitioners who they work with don't follow the same set of standards. So, codes of ethics can be thought of as big picture ways of guiding decisions. You can see there's much more emphasis on virtue ethics and principles that one can follow rather than specific directives that tell individual workers do this and don't do that. There's enough specifics in the codes that they provide guidance. They're not too abstract, but obviously not every dilemma in which a practitioner encounters will have a clear-cut solution. But on the other side, if one doesn't follow the code of ethics, it may not be illegal every day. There's certainly unethical behaviors that are not illegal, or another way of thinking about it, there is unethical behaviors that one can consider definitely being legal. But as a whole, if individual practitioners avoid or reject the code of ethics, it's much more likely that the organization, the agency, will receive lawsuits and will be dysfunctional. That will not be following the goals and the mission statements and the objectives of the fields under which they operate, or the professional goals under which they work. So codes of ethics are important things when we think about professional ethics. And when you look at news stories of criminal justice practitioners, police, law enforcement, lawyers, judges, correctional officers, and healthcare workers in corrections, as well as all the other ones, you can see both the successes and the failures of these codes of ethics in the individuals. Thank you.